Hi, everyone. Thank you so much for joining us for this training session, Confidentiality and the CARE Act, a Primer. My name is Kelly Ragsdale. I'm a Senior Analyst with the CARE Act Implementation Team at the Judicial Council. We are extremely grateful to have Arthur Weiling, General Counsel at the Rural County Representatives of California, here today to present on this topic. And additionally, we have Stephanie Lacambra on the call, who is an attorney and our resident expert at the Judicial Council's Center for Families, Children, and the Courts on confidentiality. And she will also be available to answer questions, especially during the question and answer section later today. And so without further ado, I'll hand it over to you, Arthur.
Thank you very much. Hi, folks. I'm Arthur Weiling. I'm General Counsel for the Rural County Representatives of California. RCRC is an advocacy association for California's 40 rural counties. And in that capacity, I've had the pleasure of working with the county organizations as basically the care court legislation. SB 1338 was negotiated last year, and SB 35 was negotiated this year. Before going on, I really do want to start off by thanking the really wonderful team that you have at the Judicial Council. There's just been a number of great people to work with, but in particular, I'd like to thank Ann Hadrius, who did a wonderful job representing the judicial branch's interests in the legislative process. Stephanie Lacambra, who is a fellow privacy law geek. It's been fun having those discussions. And of course, Kelly Ragsdale for herding the attorneys and kind of all moving us in the same general direction. So a little bit of background about myself. I was with the Tehama County Council's office from 2003 through 2017. And one of my very first tasks as a bright young deputy county counsel was working on HIPAA implementation, because the HIPAA privacy rule had gone into effect not too long before then. And we were trying to bring that behemoth of law and implement it in Tehama County. And I've been working on healthcare and privacy issues ever since, first with Tehama County, but then also with RCRC on behalf of our members and counties as a whole. And in doing so, met Ann, and this presentation has kind of come out of that. So let's kind of start, I think, a little bit at the top. Teresa, if you could move the slide, please. Okay, so I think it's really good, before diving into the sort of technical details about confidentiality and privacy, to really sort of start with some sort of 50,000-foot general principles, because it's really, really important to remember that confidentiality and privacy questions often revolve around very technical, seemingly nitpicky questions about this little provision and that little provision. How do they all work together? It is important to remember, though, that ultimately the questions that we're dealing with, the underlying fundamental issues, really are a lot deeper than that. I mean, ultimately, confidentiality of personal information really is fundamental to personal autonomy. The idea that you have this zone of privacy about yourself that the public and the government can't get into, that's ultimately part of ordered liberty and limited government. These are really important things. And there's often tension between that desire for confidentiality and that desire for personal autonomy and the effective provision of services, particularly when you have a population that is maybe service resistant or is just not that interested in engaging with the government. Their interest in maintaining that autonomy and that privacy does tend to conflict with the need to provide services to them. You end up with service silos, because this agency can't talk to that agency and neither agency can talk to the courts and law enforcement. And so you get this sort of inherent tension that you see playing out in the confidentiality space and the privacy space over and over and over again. I think it's also important to note that the conflict between the respondent's personal autonomy interests and the effective provision of needed services to a population that is almost by definition likely to be service resistant does replicate sort of these larger policy tensions in the CARE Act. And you'll see this as you kind of look through the CARE Act, this issue of, okay, well, here's what the respondent needs to do. Here's the services that they need, whether they may know it or not, versus protecting the respondent's autonomy. That shows up in a lot of places, everything from what is the role of the supporter, how involved are they, what is the role of the initial petitioner, when you have an order for a care plan, what does that actually mean and how is it enforceable? It shows up over and over again. Now, the CARE Act as a whole was largely intended to sort of favor, in that tense policy balance, favor the effective service provision, over autonomy interests. I mean, that was kind of the point, but very much within limits. And I think you'll note, particularly if you go back and look at sort of the governor's original conception for the CARE Act versus what came out of the back end of the process in the big white building across the street from me, you'll note that that interest in that striking the balance more in favor of service provision really did get watered down through the legislative process. And that ultimately what came out of the back end is something that's probably a lot more balanced than originally anticipated. And you see that in some areas of the CARE Act. Again, some things that lead to sort of head scratching conclusions like, sort of how do you enforce a CARE Act order? But you'll also see this, and this will become important to the privacy area. You'll see this, that there are some tensions even within the CARE Act, because there are some provisions that were part of the original draft that are maybe a little bit more less emphasis on the respondent's autonomy. And then you'll see provisions that got amended through the legislative process that are focused more on the respondent's autonomy. And you get a little bit of this tension even within the CARE Act itself. So it's just kind of important to keep those things in mind as we get into the confidentiality space, that there are some of those tensions are beneath the surface, both in general policy and actually specifically in the CARE Act itself. Teresa, next slide, please. Okay, so in terms of the sort of first principles of confidentiality, as we dive into the specifics, the first thing it's important to notice that there are multiple overlapping confidentiality laws implicated in the CARE proceedings. Again, CARE was intended to be a comprehensive, all-encompassing, effort to provide services to a respondent who needs them. And there are a lot of professional disciplines that are involved in making those decisions, and obviously a lot of potential, different types of information and different types of confidentiality law that are going to be implicated. I think it's important to note, and this is something that I remember learning very early in a lot of difficult lessons when I was at the county. Confidentiality and disclosure questions are highly context specific. So each situation where you have, multiple people or multiple departments or multiple public agencies that want to speak to one another, you have to focus the analysis in each case of one person speaking to another, who's being asked to disclose what information to whom and for what purpose. I remember I used to get questions that were along the lines of, well, okay, so a child welfare worker, a behavioral health counselor, a school counselor, and a drug and alcohol counselor want to get together in a conference room to talk about this parent whose kid's in the dependency system. Can they all talk together? And I'm like, geez, you got 4 people there. That's 12 different confidentiality analyses. I mean, the education person might be able to talk to the behavioral health person, but not vice versa. So each one of these situations, you really do need to kind of take a look at each type of communication, each type of information that is being disclosed from one person to another. Maybe its own separate analysis that might itself implicate multiple different laws. So today's presentation is going to be limited to sort of a few highlights of the applicable law that are apparently most relevant to care practice. We do not have time to comprehensively cover any one of these laws, let alone all of them. So this is going to be probably pretty high level, although we are happy to take questions on some of the more specific issues. I will note that one of the kind of neat things or maybe challenging things about making a presentation on new law is that a lot of the things we're going to talk about are ultimately unsettled. We're dealing with the interaction between a brand new statute that was intended to be transformative. CARE Court was intended to shake things up. How that interacts with existing statutes that ultimately have, in some cases, very different policy objectives. Most of the privacy statutes we're going to talk about very much favor the autonomy side of that autonomy versus service provision tension that we talked about, whereas CARE is maybe a little bit more on the service provision side. So how that interaction works yields a lot of, very difficult questions. And we certainly as attorneys can kind of give you some general thoughts as to how we think some of these things may play out. But ultimately, some of these things and many of these questions are probably going to be things that come before judicial officers as live issues, and probably on the worst, gnarliest facts you could imagine. And ultimately, the judicial officers amongst us are going to have to make those calls. So a lot of this is to a certain extent predictive. And as I like to tell folks when I'm giving presentations to my county folks, for entertainment purposes only. Next slide, please, Teresa. Okay, so the confidentiality statutes that you are most likely to encounter in a CARE proceeding. And again, this is just the top level. There's a number of others that may come up, but these are the ones that are probably going to come up over and over and over again as you dive into these questions. So top level, First one that you've probably all heard of is HIPAA, the Health Information Portability and Accountability Act, and specifically the regulation enacted under HIPAA called the HIPAA Privacy Rule. And it applies to HIPAA covers, quote, protected health information that is held by a covered entity. And these terms are both defined in HIPAA with a great deal of precision. Protected health information, as you would expect, is basically just individually identifiable information about a person's health condition or diagnosis. Covered entity is this one actually trips a lot of folks up in terms of who's a covered entity or who isn't. Most relevant for our purposes here today, a covered entity includes a healthcare provider who basically engages in electronic billing transactions, amongst other things. So if there's a healthcare provider who does any kind of electronic transaction for their billing, which nowadays all of your Medi-Cal billing and your insurance billing is almost entirely electronic, they're going to be covered. It is theoretically possible to have a healthcare provider who does not trigger HIPAA's covered entity if they're really, really old school, but for the most part, it's going to be your healthcare providers. So next up is the Confidentiality of Medical Information Act. This is a state law, and it's Civil Code Section 56.10 that basically covers medical information that is held by a provider of healthcare. Again, this is not perfectly coextensive with HIPAA for reasons that we've mentioned, but largely covers the same universe of basically medical information held by medical providers. Getting into the more specific area, Welfare Institutions Code Section 5328, it's part of the Lanterman-Petra Short Act, covers all information and records obtained in the course of providing services under certain sections of the W&I Code. I will say this does, once you dig into it, this basically covers most behavioral health facilities and publicly funded behavioral health programs. The actual scope is a little bit narrower and weirder than that, but generally speaking, that's kind of the scope of coverage for Welfare Institutions Code Section 5328. Most of the behavioral health information that is going to be relevant, or I should say a lot of the behavioral health information that is going to be relevant and necessary in a care proceeding is going to implicate Section 5328. And last but certainly not least is I'm not even going to try to pronounce that acronym, the Comprehensive Alcohol Abuse and Alcoholism Prevention, Treatment, and Rehabilitation Act, better known in practice as 42 CFR Part 2. And 42 CFR Part 2 basically covers a substance use disorder patient records held by federally assisted drug and alcohol treatment programs. And incidentally, there is a corresponding provision of California state law, it's Health and Safety Code Section 11845.5, which covers substance use records maintained by programs that are substance use programs that are regulated or assisted by the Department of Healthcare Services. So again, largely the same universe of records. The interesting thing about this one is that the confidentiality provisions that exist for substance use records were the product of really serious privacy concerns during the height of the war on drugs. The original version of those regulations, I believe, came out in 1975, and they were substantially updated in the Reagan era in 1987. And they really very heavily emphasized privacy more than the other three laws that we've talked about, because there were serious concerns that due to the heavy criminalization of drug use in particular, that folks, if there weren't those provisions, they just weren't going to get into drug treatment because they were afraid their information would be used against them and they go to jail for felonies. So that's one of those laws that really favors the sort of personal autonomy and confidentiality interest to the exclusion of almost everything else. And you'll note later when we get into SB 35, this does impact how we will use or attempt to use, or more accurately, probably will not use substance use records in care proceedings, just because the level of confidentiality there for those historic reasons really is just so much higher. Next slide, please. Okay, so some common exceptions to confidentiality protections. So common does not mean universal. In fact, as we'll talk a little bit about, some of these exceptions either don't exist in some of the statutes that we're talking about, or they're much narrower. But I think it is worth having some of these basic concepts there as we get into talking about what this means for care in particular. So the first one, probably the most obvious, is patient authorization or consent. Generally speaking, the patient owns, for lack of a better word, their own protected health information, their own medical information, and can consent for it to be disclosed. This will probably be a more common scenario in care than you might think. Anecdotals talking to the 7 cohort 1 counties that are in the process of implementing Care Court indicates that a lot of the filings that we're seeing, or at least a good number of them, are what you would call either voluntary or quasi-voluntary. They're either respondents trying to get into the system themselves, or they are people working with the respondent to get them into the system. So we've seen public defenders trying to do this for folks that are in criminal proceedings. We've seen courts kind of trying to, encourage defendants that are in proceedings in front of them to sort of agree and get into care. So I think you're going to see that in practice, probably a lot of these cases, or at least a good number of them, are going to involve a situation where the respondent, they may or may not want to be in care, but they're willing to share their information as necessary to allow that to happen. The second one is disclosures for purposes of treatment. So this is something that is permissible under HIPAA. It's permissible under the Confidentiality of Medical Information Act. It's actually, disclosures for purposes of treatment are actually somewhat limited under WNI 5328. It's usually disclosures for treatment is only permitted without the consent of the patient if the provider that is getting the information has a direct treatment relationship or direct treatment responsibility for the patient. So there's actually some, again, as we start getting from general health information more specifically to the more sensitive, at one time more stigmatized area of behavioral health, you're starting to see a little bit of sort of curtailment in the open sharing of information, even for treatment purposes. And we really see that when we get into 42 CFR Part 2, which is again the drug and alcohol treatment records, where really free information sharing without consent is really limited to to providers that are within the same drug and alcohol program or working for an entity that has administrative responsibility for that drug and alcohol program. So under 42 CFR Part 2, sharing substance abuse records between programs, generally speaking, you have to have consent. And again, that's because of those just real sensitivities around that particular type of treatment record. Dangerous patients. So this is something, this is an exception that exists. Basically, we'll be very familiar with this from sort of the TerraSoft context. This deals with patients that are basically a substantial and imminent risk to basically identifiable people. There are provisions allowing for disclosure under those circumstances under HIPAA, CMIA, and Welfare Institutions Code Section 5328. Interestingly enough, there is a corresponding exception for this in the drug and alcohol world for substance abuse treatment records, but you actually need to get a court order there. So if you've got someone who's a patient in a federally assisted drug and alcohol program and they make specific threats, there's actually a process you have to go through. You can't just call the police and say, hey, this happened. I haven't seen that actually litigate in terms of the potentially conflicting duties under state law, tort duties under state law, and the federal regulations, but that tension is very much there. And last but not least, disclosures that are required by law or in connection with court proceedings. And this is where you actually do start seeing some real cleavage between the various legal regimes that make these things confidential. And really, you're going to have to start doing some independent analysis that's going to look a little bit different under HIPAA than it does under CMIA, than it does under 5328, and then it does under the substance abuse regulations. So generally speaking, both HIPAA and CMIA do flat out allow for disclosures that are explicitly required by law. Not voluntary, you may disclose, but if state law says you must disclose, HIPAA allows you to do so, CMIA allows you to do so. Where we're talking about things like subpoenas and court orders, again, HIPAA and CMIA both allow you to make disclosures that are specifically required by court order. And we'll see that as we get into SB 35, you'll start seeing some of these things start to play out. However, where there are subpoenas, both HIPAA and to an extent, but HIPAA requires that with the subpoena where medical records have been subpoenaed, the patient has to be given an opportunity to agree or object. And ditto under CMIA, you generally have to go through the notice to consumer process. So again, we're starting to see a little bit more protectiveness there where there isn't actually a legal mandate or a judicial officer involved. Section 5328, again, no provisions for subpoenas. I got a whole bunch of them quashed on those grounds back in the day. There are provisions that allow for the disclosure of behavioral health records to the courts as necessary to the administration of justice. Not a huge amount of law on exactly what that means. And moving into the substance use disorder space, there are provisions for disclosure of substance use records by a court order, but if you really want to dig into it's a 2 CFR 2.63 and 2.64, really dig into those areas, you'll see that it's really hard to get those court orders. There's a very elaborate process that you have to go through, very difficult findings the court has to make, and only under certain circumstances can even a court order authorize that information to be disclosed. I think one plea I usually have for judges in this area is judges and attorneys, please don't try to get substance use treatment disorder records. It's really, really hard to get those for use in a judicial proceeding, and is likely to lead to a humongous amount of wrangling with the program, with the individual patient, and then with whoever is seeking the records. It's a really, really difficult thing to do, and that's just as true in care as it's going to be anywhere else. Next slide, please. Okay, so diving from the general to the specific. So when the CARE Act was originally being negotiated, this is back in 2022 when Senate Bill 1338 was winding its way through the legislative process, there was a recognition that confidentiality laws and privacy interests were potentially going to be implicated here. In fact, the county negotiating team, of which I was a part, made the point fairly loudly that, hey, you've got this scheme set up under which county behavioral health agencies are required to, upon court order, required to investigate the respondent's mental health condition and make a report back to the court. If we don't have some explanation as to how that interacts with the confidentiality laws we work under, which include HIPAA, CMIA, 5328, if we don't have some sort of clarification and frankly, some sort of exemption that allows us to talk to the court, we're not going to be able to do our job. If we've got a respondent that has been seen in county mental health before, which again is probably a fairly good percentage of the service population, if we can't tell the judge about that, we can't explain why we do or don't think this person is care eligible. That's going to be a problem, like a big problem. And this was recognized when 1338 was being negotiated. The reason that it did not, that ultimately there were no provisions in the original CARE Act wasn't that this wasn't on the table. It's that there were honestly policy differences between the administration, which generally favored, hey, let's give the court every piece of information that it needs, and let county behavioral health disclose the full contents of its records to the court when we have a care petition, versus in particular the Assembly Judiciary Committee, who said, hey, that's striking the balance a little bit too far in favor of the care proceedings. We really need to take a little bit more care of the respondent's autonomy, maybe put some guardrails and some limits around what can be disclosed. And ultimately, those negotiations fell apart before the CARE Act ultimately got enacted. So after the CARE Act was enacted, and we kind of moved into the 2023 legislative session, and October 1, 2023 was kind of creeping closer for those cohort 1 counties. One of the priorities that the administration had, one of the priorities that we had on the county side, was trying to basically get this issue figured out. Because again, without some explanation of how we can communicate protected information to the court as part of the care proceeding, county behavioral health agencies were concerned that they wouldn't be able to do their job, that they'd be caught between a court who needs information, has the ability to issue sanctions, and probably isn't going to be happy if the answer is we can't talk to you, versus obviously the provisions of these laws, which are enforceable through an interesting array of civil, criminal, and administrative penalties. So thus became Senate Bill 35, and that was the major set of changes to the CARE Act that ultimately did address the privacy issues, I think, as well as can be addressed, in the context of state law. So first off, and this is, I think, important for, obviously important for the court folks, because we were, as part of SB 35, addressing the disclosure of some very sensitive information to the court, there was a corresponding desire to make sure that those court records are, confidential in general and subject to sealing in particular. So there are very detailed provisions, in section 5976.5 and in several other places that really do make pretty much all information and records that are submitted during a care proceeding confidential, allow the respondent to request that they be sealed and have a presumption in favor of sealing. There are also, as we will talk about in a little bit, there are provisions that really restrict the reuse of that information. So information that gets disclosed in the care proceeding or the reports that get filed by county behavioral health that restrict those from use in subsequent legal proceedings. So there was really a lot of concern that if we're going to open up the gates to sharing of behavioral health information and medical information in the care context, that not cause a permanent loss of privacy for the respondent, that stay bounded. And there's really, you'll see some what are frankly duplicative provisions, very much overlapping and duplicative provisions addressing the the confidentiality of court records that were really because of that high level of concern. So getting back to how did the legislature sort of split the baby when it comes to sharing information with the courts, it actually split it up into a couple of different bite-sized chunks. So first off, the disclosures by county behavioral health to the court, in particular in the context of that initial investigation report. The legislature has made those disclosures mandatory. Those are disclosures that are required by law. So I'd really encourage, as you get into this issue, take a look. It's 5977.4D of the Welfare Institutions Code. The legislature actually outlined exactly what their not just what the requirements were, but they actually specifically sort of highlighted, this is what we think this kind of disclosure is. So with regard to communication from behavioral health to the court, that's a specific mandate. The report that behavioral health has to prepare is required to include protected health information. And there's a specific mandate to behavioral health. You must provide that information to the court. The idea being to essentially trigger those provisions in both HIPAA and CMIA that allow for disclosures as required by law, therefore establishing a framework under which this information can be provided. Now, there are exceptions, and in particular, as we talked about, drug and alcohol information, the federal requirements for that are a lot tougher. Simply being required by law does not allow you to disclose that information. So generally speaking, that has been carved out of SB 35. There's a specific provision that says, well, notwithstanding the general requirement to make disclosure that we just talked about, that doesn't cover drug and alcohol records except to the extent permitted by the drug and alcohol regs. And I'll tell you that for most part, the drug and alcohol regs, absent consent, just don't allow for disclosure. So you're not going to see a lot of those unless you have a cooperative respondent. The SB 35 also addressed disclosure, not just by behavioral health to the court, but also disclosures from other treatment providers to behavioral health, particularly during the investigation process, because that's the central function of behavioral health at the opening stages of a care case. Is judge gets the petition, makes a prima facie determination, sends it over to behavioral health with an order, go forth and investigate and tell me if this is supported or not supported. If behavioral health can't talk to other providers, or more accurately, if other providers can't talk to behavioral health, that investigation gets a lot harder. So again, the legislature took kind of a bit of a nuanced approach here. So with regard to providers that filed the CARE Act petition, because there are providers can file CARE Act petitions, several of the categories that are, I think, in 5972, or I'm sorry, 5974 of the W&I code are providers of healthcare. So if they've either filed the petition, or in some circumstances, a CARE petition is required to have I call it a doctor's declaration, even though it's not technically a doctor's declaration, but need to have an affidavit by a licensed professional person. If a treatment provider either filed the petition or acted as the licensed professional person, they're required by law to share information that they have about the respondent with behavioral health. The theory being that if they filed the petition, and that they've put this an issue in front of the court, that they need to make full disclosure to behavioral health, so that whatever it was that they based that filing or that affidavit on can be vetted, and a report can ultimately be made to the court, who can then make a fully informed decision. With regard to other providers, so these are folks that did not file the petition, did not sign the affidavit, and are not themselves behavioral health. The law provides for permissive disclosure. They may make disclosure to county behavioral health, but they are not obligated to do so. And the legislature very clearly, and again, somewhat unusually clearly, made it clear that they believe that those disclosures from other treatment providers to county behavioral health are disclosures for treatment purposes that are permitted under HIPAA. Now, the legislature's belief on that subject ultimately is not binding. This is a question of federal law. What do these federal regulations require? But obviously, the legislature did explain to the courts, this is what we think we're doing. This is how we understand the relationships. Again, not binding, but intended to provide guidance both to the courts, but also to treatment providers who are trying to decide, hey, can we make these disclosures? I'm trying to explain to them essentially, this is the legal analysis under which those things appear to be permissible. I will note that there is that the question of whether a treatment disclosure, whether that's permitted when the treatment in question is involuntary, because again, a respondent at this stage is not necessarily a voluntary participant in the care process. That's actually a bit of a controversy. There's a case out of the New York Court of Appeals, which that's New York's version of the Supreme Court, that holds to the contrary. It's a case called In Re Miguel M, that basically says, no, treatment is limited. HIPAA's treatment exception is limited to voluntary treatment. And that actually was a big deal in New York because it essentially hamstrung their version of care court, which is called Kendra's law, has been very difficult to implement because of that ruling. I will say that's, I think there's plenty of room to disagree with the court in Re Miguel M. Obviously, our legislature does, but that is an area where if you've got a treatment provider who wants to make disclosure or potentially has made disclosure and you have a respondent going, hey, they shouldn't have done that, that violated HIPAA and here's why, that's a question that judges are going to have to look at is, okay, was that disclosure permissible, not merely just under state law, which clearly says that it is, but also under federal law as well. And that's going to be one of the, I think, ones that come to you. I tend to think that the legislature probably got this one right, not just because I was involved in writing that legislation, but ultimately that is going to be one of those tough judicial questions that is going to come before some of you that are judicial officers that are here with us today. There are requirements for when providers give information to behavioral health. There is a notification requirement. This is not a prior notification requirement, doesn't provide like an opportunity to object. It's basically, hey, I have provided this information, or this provider has provided information to county behavioral health, and here's what it is. And it goes to the respondent and their counsel, and it is the county that is responsible for giving that notice. It's designed to, at least ensure that there are no surprises. And if the respondent has a problem with this, they can certainly at that point go to the court and make clear whatever that problem is. There is a provision that allows for the county to apply ex parte for a court order to compel a provider to make disclosure. So for instance, if you've got a provider who filed the petition that is basically not cooperating with the county, there is an ex parte petition process. Again, not a lot of procedural detail. So that's again another one of those things that when this happens, the courts are going to kind of have to figure through. But there is a provision that allows for the county to ask for and potentially obtain a court order requiring disclosure. As noted above, the disclosures that are made under these circumstances, either from the county to the court or from treatment providers to the county, may not include psychotherapy notes. So psychotherapy notes are a piece of information that is considered particularly sensitive, especially within the context of HIPAA. Generally, those were carved out of SB 35. Also, substance use treatment records, as we talked about, those can only be included to the extent permitted by 42 CFR Part 2, and that extent is very, very little. So you're probably not going to see those too often. Next slide, please. Okay, so one of the things you'll note if you want to geek out and actually go back and read through the actual text of SB 35, you'll notice that there's not a lot of discussion about privileges. In fact, there's no explicit discussion about privileges. And you may ask, why is that? Was there an assumption that whenever we're dealing with a care court, there's an exception to the various privileges of physician patient, psychotherapist patient that naturally applies? Is it because there was a legislative belief that SB 35 automatically abrogates those privileges? Or C, did the issue just not come up during the legislative process? Strictly speaking, the answer actually is C, but realistically, that doesn't mean we don't have to analyze them. So when it comes down to the question of privileges, obviously some of the ones that are potentially implicated here are the physician-patient privilege. Again, if we're dealing with a behavioral health provider, if we're dealing with a doctor in the community, obviously the physician-patient privilege is going to attach in some of those cases. There is, however, an exception to the physician-patient privilege for proceedings. I've actually got it up here as proceedings to commit the patient because of his, again, gendered language back in the olden days, alleged mental or physical condition. If you actually look at, this is Evidence Code section 1004, you'll actually see that the way it's phrased also allows for an exception in proceedings to place the patient or their property or both under the control of another because of their alleged mental or physical condition. And I think there's probably a pretty decent argument. Again, some of you on this call are judges and will be the ones that need to make the call, that chances are good that the CARE Act, although again, the level of compulsion in the CARE Act is inconsistent, not entirely clear, I think there's probably a pretty decent argument that CARE Act qualifies as a proceeding to place the patient, at least to some extent, under the control of another because of their alleged mental condition. So I think there's probably a pretty good argument that Evidence Code 1004, would cover the physician-patient privilege in the context of care proceedings. A little bit more interesting is the psychotherapist patient privilege. And the psychotherapist patient privilege is going to apply, again, to a lot of the people that need to make disclosures to make care work, whether that's the folks that are that have worked for county mental health, that have seen the patient before and have generated records about their condition, to certainly treatment providers that are in the community and either participated in the petition or are being asked to assist with the investigation process. Chances are decent that some, if not all of that information is naturally going to be covered by the psychotherapist patient privilege. Now, there are a number of exceptions here, some of which may be applicable, some of which are maybe more clearly applicable or inapplicable than others. Obviously, one of the ones, again, going back to the discussion we had about consent before, obviously, if the patient has waived the privilege by voluntarily signing something saying, I'm comfortable having my records shared for this purpose, obviously, you don't have a problem. I think two of the others that you're going to get in context of what I'll call involuntary care cases, because of course, not all care petitions are voluntary, are court-ordered evaluations. So in other words, a psychotherapist appointed by the court or an order of the court to examine the patient. This would, for instance, be, if the court makes an order to county behavioral health, we want you to go out and investigate person X. The therapist that goes out there and participates as part of that investigation team is probably covered by that exception. Probably more interesting, and I think this is probably going to be the one that, if this ever gets litigated in a serious fashion, is probably going to be the sort of where the focus is Evidence Code section 1024. And so this basically provides for that there is no privilege under this article if the psychotherapist has reasonable cause to believe that the patient is in such mental or emotional condition as to be dangerous to himself. Again, sorry about the gendered language, it's old school, or to the person or property of another, and disclosure of the communication is necessary to prevent the threatened danger. And I remember when this week we're kicking this issue around internally, and somebody raised this. My initial reaction was, a care petition is the equivalent of a TerraSoft warning? You've got to be kidding me. But actually, it's, I think, probably a little bit more detailed than that. So Evidence Code section 1024, this particular exception for, dangerous patients, actually predates TerraSoft. It goes back to the Evidence Code revision in 1960. And as the courts have explained, a case called Mavridis versus Superior Court, this particular exception to the psychotherapist patient privilege, was designed to enable therapists to initiate commitment proceedings and to testify in those proceedings. And there's some interesting language in it. It's a case called People versus 1 Ruger 22, and in actually the Chief Justice's dissent in a case called Matthews versus Becerra, that takes a pretty broad view of this exception. It basically kind of notes that there is really no seriousness requirement in terms of how that, or imminence requirement in terms of how dangerous does someone have to be to trigger this exception. And I think there's probably a pretty decent argument that someone who meets care eligibility criteria, so take a look at those care eligibility criteria, which talk about things like the person is unlikely to survive safely in the community. Participation in the care would be the least restrictive alternative necessary to ensure the person's safety. I think you could probably put together a pretty decent argument that someone who meets those care criteria, or there's reasonable cause to believe they meet those criteria, probably comes within the scope of what is a dangerous patient for purposes of the psychotherapist patient privilege. The reason all this is important is that the psychotherapist patient privilege and the physician patient privilege, they both operate independently of the confidentiality statutes. So you can have information that is normally confidential under the confidentiality statutes, but for which an exception exists, but still be privileged. There's actually cases on this. In Ray SW, I think, is the big one from 1978, in which there was information that was clearly an exception in 5328 that allowed it to be disclosed to the court. And the court said, that's nice, but it's still covered by the psychotherapist patient privilege. So these privileges do operate independently and do need to be evaluated independently. I think a couple of interesting questions that sort of come up in addition to the sort of naturally do the exceptions apply is that, one, how far does this privilege issue go? Obviously, privileges, generally speaking, apply to disclosures in court or in administrative proceedings where testimony can be compelled. To what extent do they affect, physicians in the community talking to behavioral health? Is that a privilege question? Because behavioral health might then turn around and put that into a report, or is the privilege not applicable there?